Our veterans need your support. Foxfield Farm for a Recovery Mission is a not-for-profit organization that has been established to provide an equestrian groundwork training program for U.S. veterans with PTSD and related issues incurred through military service. This curriculum will be offered at absolutely no cost to any veteran participating in the program. This foundation will also incorporate the repurposing of rescue horses and locating new, responsible owners. The synergy of the work invested by the veterans to aid the recovery of these horses is equitably therapeutic. Please go to our website to be a supporter, www.foxfieldrecoverymission.org. Thank you.
Here's your host, Sylvia.
Hello, and thank you for joining me today. It's my pleasure to be here in the law offices of Greg DeMonch and also with Jeff McChristian. We're delighted to be here today, and hopefully we're going to be clarifying some areas of laws and litigations and informing our folks and our viewers about things that we feel are important to talk about these days. And certainly I'm sure it will be of great interest to them. So let me just start with you, Greg. You've had a very broad background in various community efforts. You've done a lot of different things. I know you've been a Boy Scout leader. You've been involved with the First Company Governor's Horse Guard. You've taught in school and so forth. Now, would you consider those avocations or it kind of, but they do contribute towards, I think, the whole of being a lawyer and dealing with people in general?
Well, yes,
Susan.
Susan.
That's true?
Yeah, I think it is true. And I was with UTC for 4 years as well and taught school for 4 years. And they were careers at the time, but they were also enabling me, or enabled me to develop an understanding of those environments. And we represent clients of all types. And one of our goals in representation is to understand the client and to be able to communicate with the client such that the client will understand and we'll be able to move forward together in any matters.
Well, I think it's important because you have worked at in these varying capacities, is that people are often intimidated by law, litigation, going to trial. The minute anybody gets anything in the mail that says attorneys at law, there's a feeling of nervousness. And I think with your demeanor, if you will, that helps. There's compassion there.
Well, we certainly hope so, and you're correct. When individuals are served with papers or are involved in disputes, it is a stressful time. Interestingly enough, the law is even if a lawyer is stopped for an act, they're still required to receive Miranda rights, even though they should know them already.
Sir, of course.
You know, so that's a good, you know, it's a good analogy in that respect. It's a scary place for laypersons, and that's why we're here.
Well, Jeff, let me ask a little bit about your background, but I know you're on the litigation side, and I think that it's a little bit like a doctor. When a doctor becomes ill or might even suspicion they have something wrong with them, they've got the inside track of knowing about what it could be, might be, you know, all the high signs. And I think that, as you said, that even if either of you or any lawyer is in a car accident or whatever, you know all the things that could possibly happen given the situation. You know, there's a little bit behind that.
Yes, yeah. We're in the system,
Yeah.
so we have some.
You're well aware.
Inside knowledge, if you can call it that, and you know, it's not unusual for lawyers like everybody else to be involved in car accidents or pulled over for speeding, or hopefully not anything more involved in that.
Right.
But I was involved in a very minor accident on the way to JFK Airport a year ago, June, and I am the subject of a lawsuit. And things are different in New York than they are here.
Sure.
But I certainly, know enough to, I hope, can assist, my counsel, who is provided by my insurance company, in getting this thing resolved as quickly as possible.
Now, you have been, I believe, let's call it in the business of law for over 35 years. Is that correct?
38.
38.
Unlike Greg, I didn't have prior careers. I went straight from college to law school.
Was there an incentive in some part? Was there some catalyst that said, I want to do it? Your dad was a lawyer or whatever. Was there, or is this just something that suddenly I'm here in college and I think I'm going to go into law?
There was no grand plan, Susan. I thought when I went to college that I was going to medicine, and that was short-lived. But I changed course and
Right.
ended up from college going directly into law school,
Yes.
thinking that I wanted to be in a helping profession. And then after law school, basically went out and hung out my shingle with a law school classmate and a young lawyer who'd only been out a couple of years, and we had an awful lot of fun, and we learned an awful lot,
Yes.
and we took just about anything that came in the door, which has continued to inform my practice, which has been very general
Sure.
over the years. So
Sure.
I do a lot of different kinds of litigation, but I also, with Greg, do real estate, residential and commercial, probate matters, contested probate matters, estate planning and administration, small business representation. So I like the variety of it. I'm always learning, and it's been great. And I'm in year 38 and don't feel like slowing down.
Yeah. Well, I think the thing is that obviously when you go into law school, then there's a determination on some part where you're going to put that emphasis, whether it's going to be corporate law or maybe be a prosecutor or the public defender, and there are various things. But when you said that you're a little bit of everything, it's a bit of a smorgasbord for you. More specifically for Greg, it's in the real estate and so forth.
Correct.
Are you seeing, because you are in all of these residential, commercial real estate, you're also for depository and non-depository financial institutions. What exactly is that, depository and non-depository?
Well, there are different classifications of lending entities. A depository institution would be like a bank. A non-depository institution would be like a first or second mortgage lender
I see.
in Connecticut. They don't take deposits, but they are licensed to lend money, most notably with residential refinance, residential purchase transactions, and commercial transactions.
Would that be, and correct me if I'm wrong, credit unions or?
Credit union would be a depository institution.
Okay.
Yeah, that would
All
be a
right.
depository institution because they do take in deposits, but they also lend money.
Yes.
Foreclosure money, mortgage money, and most notably car loans. A lot of credit unions
Right.
are famous for car loans.
But the non-depository would be like the mortgage origination firms.
Right.
Oh, okay. All
Yes.
right. Okay. Then you sometimes see those advertised on TV and so forth, other lending places. And you have to
Yes.
be very careful. There's a lot of fine print there. You need your lawyer to read that very carefully.
Well, it's a very heavily regulated industry, and especially so since October 3rd of last year, where the new so-called TRID rules came into effect. That is the Truth in Lending, Real Estate Settlement Procedures, Integrated Disclosures Rule, which dramatically changed loan originations and loan closings.
You know, I've often been interested when you do a mortgage thing and then after the papers are signed and everything's all done, you figure, okay, you get 3 days, I think it is, to change your mind. I've often thought that was a funny little, do people change their mind that often?
Not very often, but
Okay.
that rule has survived
Yes.
the changes. That's the refinance
Yes.
3-day rescission rule. And the new rules have now imposed a know before you owe requirement, whereby a purchaser now gets is required to receive what's called a closing disclosure 3 business days before the closing.
So
they've taken that and they've
moved it
they've
back.
added it.
Yeah, I see.
They've added
Okay.
it to other transactions.
I see.
Which I think conceptually is a good rule. We find that our clients come to the table, the closing table, for residential real estate transactions with a much better understanding as to what the numbers are. And we are receiving fewer questions at the closing table regarding why this number is what it is. So I do think it's a good thing. I think it was it's any type of new law can be scary, and lenders are now
Sure.
strictly liable for mistakes,
Yes.
whereas before not so much so. So I think the intent was well placed, but I think that the Consumer Financial Protection Bureau, that's been in the news quite a bit lately, needs to understand a little bit more about how the boots on the ground are handling this. And I think that it's a fluid situation,
Yes.
and I think it's going to evolve and hopefully become a little bit more user-friendly for all the participants in the process.
All right, well then, just to bring something which I think is often a common decision to be made for people, particularly first-time mortgagee people, taking out a mortgage on their first house. Better to have your own lawyer than to have one lawyer representing both partners. Yes, better to always bring in your own lawyer to I guess, take care of your side, protect your side.
Yes,
Okay.
that's a definite yes. And generally speaking, one lawyer is disqualified, if you will, from representing a seller and a buyer. There are exceptions, and waivers have to be filed or have to be agreed to, and engagement letters need to be signed. But in general, a seller and a buyer should have different counsel, unless it's a family transaction or something of that nature. And in addition, in Connecticut, we have what we think is an easier process for the client, for the buyer. In Connecticut, we would generally represent not only the buyer, but
Yes.
the lender, and also we would be the title insurance agents and be able to issue
Right.
the title policy, versus a jurisdiction like New York, where you'll generally have a separate attorney for the lender, a separate attorney for the buyer, and a separate title company attorney. We think it's easier here. It's not any more expensive, and in many cases it's cheaper than a lot of the other jurisdictions.
All right, Jeff, back to you. I want to ask each one of you, but in your particular case, since you have a wide variety of litigation that you address, are you seeing any trends these days of a growing segment of the particular areas that you can defend or prosecute clients for?
That's really hard to say, Susan, because I'm down in the trenches, and it's very seldom that I get to come up to 10,000 feet and look down and say, "Oh, so these are the trends." But I think probably, and this may not be as specific as you're looking for, but what has been happening that I noticed in the last several years is a real, I think, pronounced emphasis on alternative forms of dispute resolution, both built into the judicial department here in the state when you're involved in litigation, and both out and also outside with private mediation services. And the reason for that
Is that a less expensive route to go, a quicker, or?
the reason for that is both it's cheaper and it's faster. And the courts are so incredibly
So give us an
clogged.
example. Let's say someone comes to you and says, "I want to do this," and you'd say, "Well, there's another way we could do this." Give us an example.
Well, that's a good question. I'm going to choose for my example a situation which already involved in litigation, where somebody has come in and sued, and the defendant has had to retain a lawyer and prepare a defense. But then, in the midst of that case, when people sort of get to a cooling off period after the initial salvos have been fired, they consider something called Judicial Alternative Dispute Resolution, JADR, which the Judicial Department has judges, both trial court and appellate court judges, who will serve as mediators, fee-free. And you just file a form, you pick a couple of judges and some dates, and then you get assigned a judge. There's a mediation center in the Hartford Judicial
It
District.
sounds sort of like a small claims court.
Oh no, these.
okay.
I was recently involved in a mediation involving a contract dispute over a house being built where a couple of $100,000 is involved.
Okay.
That's used a lot of times in car accident cases. I had one recently that settled a long-standing dispute that was a title dispute over commercial properties that were contending over a right-of-way and access to and from shopping centers.
Right.
So, but what it permits the parties in front of a judge, and most mediators will listen to everybody
Yes.
and separate the parties,
Yes.
to get their story out without having to worry about all of the objections
Right,
and
right,
having the
right,
jury
right,
step out
right.
and argue them to a judge. And so they get the sense that they've had their day in court and they've been listened to by
Mm-hmm.
an experienced jurist who then, instead of making a ruling all for one or
Right,
the
right,
other, says,
right.
well, why can't we come together and give
Not
you
a
guys...
pass or fail for everybody.
Well, yeah,
Yeah.
but it gives the parties more control over the process of getting to a resolution, because when you pitch it to a judge or a jury, it's a crapshoot, quite frankly. You don't know what you're going to end up
Right,
with.
exactly.
And it usually results in a resolution that is much more final, shall I say. No appeals typically.
So
from
if
that.
you had a sort of a typical case of settling this way, let's just say in that particular case, it could have been months over here, and this could be a matter of weeks.
Oh, let's take years
Yeah.
in court
Wow.
and months in mediation.
Wow.
That's a better description
All right,
from the
so
timeline.
there's a good thought. So if one would still want to, if one had an issue, a situation, either where they had been served papers or were advised as such that they were going to be caught up in something, or they wanted to take action on it, you still go to your lawyer and you say, I'd like to be able to do this, and I understand there's another way. So you would still go there and then determine what seems to be the most appropriate.
Yes, and I would also say that I think a lawyer who is doing his or her job as a counselor, we wear many hats. We're advocates, we're champions, we're warriors, but we're also advisors and we're counselors. I think I consider it part of my professional responsibility to say to somebody, you understand that litigation, the results are uncertain, it's expensive, it's going to take a long time. Here's another way. And I find most lawyers on both sides of an issue are receptive to that. And it's a lot of times we have to convince the clients to do that. And I will also say that many of us in practice do that outside of a formal mediation process, that we move our clients in the direction of a settlement. So they might not get exactly what they want, but they get something better than nothing.
Or take a big risk of losing it all.
Correct.
Well, I think it also gives you credibility as a lawyer too, because you're looking for, again, the most expedient, the least expensive route, the solution. I mean, you're in the business of solving problems, as it were,
Yes.
solving discussions or solving arguments, or however one might put it in layman's language.
Yeah.
That's essentially what you're doing. Are you seeing in both your areas? Are you seeing just because of our societal, cultural atmosphere of, I think there's a recent thing on campus, if you don't like a Halloween costume that you've seen and you feel as though that's been offensive, you can be, I mean, are a lot of things getting kind of silly these days, malpractice suits, and people are just picking up the, gauntlet and flinging it down in front of people because it seems to be an easy route to go? Are you seeing that?
I don't see that in my practice.
Okay.
And again, it's hard for me to get to 10,000 feet to see if there's trends. But I think that generally we have a litigious society, and that people are very quick to say, well, I'm going to go and
Right.
sue you for that, or I'm going to protect my rights. And we all have rights, but it's another thing entirely of what it's going to cost to enforce
Yes.
them. And rights are not absolute, and there's always a balancing that goes on. And just to finish the point that we were talking
Yes.
about before on the mediation, I tell my clients, and I know there are a lot of lawyers that do this in almost every case, it's better to negotiate than
Yes.
litigate.
Yes.
And sometimes the other side takes that option off the table.
Yes.
But that is, blessed are the peacemakers.
Yes, yes.
And so we do a lot of peacemaking,
Yeah.
Lawyers as a rule.
I think there's an expression going around, I'm not going to get it quite right, but you don't want to get to the pounding on the table. That was either you start out, you bring facts to the table, you bring the law to the table, and if neither of those work, you pound on the table. But we don't want to get to the pound on the table
Correct.
department. Yeah,
Yes.
that can be embarrassing and
It's rarely fruitful,
Yes.
but it does happen.
Yes. Yes. All right. So, Greg, if people were to, I think it's pretty obvious if you get served papers in the mail, and you see it's from a lawyer and something happened, and you know you had a car accident 2 weeks ago, and you thought we were going to just exchange insurance cards, but now there seems to be an issue because the other person has a neck problem and so forth. So, you know, you're concerned about that. But let's say in your area of expertise, are there things where people should be aware of red flags of things? Whereas there's a litigious society these days, sometimes are people not going to a lawyer? Are there things that people should consider going to a lawyer over that may not be necessarily quite so evident to begin with? But you said, am I making myself?
I think you are. Yes, you
Yeah.
are. And I think that let's stick to let's say residential
Yes.
real estate area.
Yes.
In central Connecticut, the realtors really take the lead. They are really the boots on the ground. They're out there with the buyer, with the seller, and the contracts are drafted by the realtors, many times subject to attorney review. And the process is a good one.
Yes.
And I think that it keeps the tenor of the transaction down, because if the lawyers have to be engaged at an early stage of that process, it seems to raise the anxiety level. And that's something that we would prefer not to do.
Yes.
Every now and then it becomes necessary, and that's fine. That's what we do for a living. But we prefer to, in general, stay in the background, act as advisors to the client, to the realtor, and let the realtors take the lead on the residential real estate side. On the commercial side, it's different. You have commercial brokers out there that do that in part, but
And it involves the public if it's commercial too.
well, the
It's not-
commercial in respect to, for instance, a residential would be like a house.
Right, right.
Commercial would be a business.
Stop
they're
and
buying
shop
a business,
or
a stop and
whatever.
shop. They're
Right.
buying stop and shop. They're buying the real estate. They're buying the assets. The attorney engagement begins with maybe a letter of intent, or maybe even a handwritten note between the parties, and then the drafting of the contract takes place. So they're two really different animals.
Yeah, a point I might mention is something adverse possession. For instance, let's just say you buy a house, there's a fence that supposedly you assume it's somewhere, it's where the fence line should be, dividing the property between you and your neighbors. You want to put up a new fence, a different kind of fence, maybe one that gives you more privacy or whatever. And so you go to do it, and so you have a survey done because you want to make sure it's in the right place. And to your dismay, you find out that apparently your neighbor, the fence is actually, you actually own another couple of yards of real estate there, going all the way down the sideline. And so therefore you need to do something about that, because if you let that run on too long, too many years, it becomes their property. Is that correct?
That's right. There's a 15-year running for an adverse possession or a prescriptive use, a prescriptive easement. And those are questions of fact.
So that would be a case where maybe I better at least send a letter over to my neighbor and say, hey, the fence is coming over your way a little bit.
That might be one remedy
Okay.
on how to address that, but again, it's very fact specific. It has to be an open and continuous, exclusive adverse use.
Yes.
And those, again, are all statutory questions of fact. So someone calling us
Yes.
and giving me those limited facts, I wouldn't really be able to conclude, where they stand. There's a lot more that would need to be done in our
Yes.
due diligence and our discovery as to what do we really have here in order to formulate a strategy going forward. But that's a very good example, and it's actually one of the questions that we pose to our clients on residential real estate. Does the property share a driveway?
Yes.
Does the property have a fence?
Yes.
Yes, it does. Well, whose fence is it? Well, we
Right.
think it's the property's.
Right.
Well,
Right.
here's the deal.
Right.
Virtually no one in this area pays for a survey on residential real estate. But I will say that many years ago, clients that were relocating with employers, the relocation package did include a survey.
Yes.
So since it was paid for,
It's a great thing to have.
they
really.
had.
Yeah.
And
Especially if you have a large property.
well,
you know?
that's right.
Yeah.
And what I took note of, again, this is now many years ago when these surveys were paid for by the company, I would find that when those surveys came to my desk, there was an issue in probably 2/3 of them.
Sure, because the old farmers used to go from a rock to a tree to a certain
to where the old tree
point
used
on-
to be.
Right, and now it burned down, or the lightning
You know,
got it, or
right.
whatever.
But those are issues. Those are lawyer issues.
Right.
And part of our job is to pose questions to the client that they really don't know what they don't know
Sure.
what to ask.
Sure.
But in respect to use of attorneys, I think when individuals get into a situation where they are uncomfortable with where they stand, whether they go to the realtor or they
Yeah.
go to the attorney or they go to the insurance agent, they need to really, it would behoove them to go to a participant in the settlement process that is the expert in that particular area.
Yes, a
You know,
specialist, if you will.
That's right.
Yeah,
That's
like
right.
a
If you're
doctor, you go
right.
to your primary care physician,
Right.
and then when you've got a particular issue with your muscles, that's another guy.
Right,
Well,
exactly.
yeah,
What
yeah.
we don't want to see is an issue that doesn't present itself until
Yes.
close to the end of the transaction. It can become much more problematic to deal with it at the end of the line
Mm-hmm.
as opposed to the beginning of the line.
All right, well, just very quickly, because our time has gone by fast, and I think it's a very interesting subject. We could be here for a week, and I think a lot of interesting things. But there's some call to action, class action suits, such as there's a talcum powder one out there, and there's also one where they have sites such as LegalZoom, and we're not picking on anybody here. We're just saying, what are your feelings? Let's say about that website, LegalZoom. I mean, it looks like it's a quick fix. Good idea or okay or
It's like individuals searching.
I'm not actually be judge and jury on this, but just
Well, no,
generally.
no.
speaking.
For information purposes,
Mm-hmm.
maybe it's not a bad starting point for someone looking to let's say draft a will.
Right.
But I must say that we have seen many clients over
Mm-hmm.
the years come in with these self-help documents that are either defective or simply ineffective.
Mm-hmm. Or don't hold
completely.
water.
Or don't hold water.
Yeah.
We're not espousing the Full Employment Act for lawyers, but the client should have confidence in the documents that are prepared, whether by them or by a third party or by an attorney, that those documents are going to effectuate exactly what the client wants.
So
And
there we go. Yeah, just to say to viewers, take a look at it. Maybe give it a first glance and so forth. And if you've got a fairly serious position, go to your lawyer.
Right. Proceed with caution.
Yeah,
Proceed with
proceed with caution. And just to amplify that briefly is that, your doctor analogy is good. A lot of people now go online on, any of the MD sites to get some background information, but you're not going to treat yourself.
No.
So you go armed with that knowledge to your appointments with your doctors.
Just so you're well informed.
We're a profession.
Right, exactly.
And you should proceed with caution when you want to engage
Sure.
in practice in that profession
Sure.
without the necessary
Well, just to
qualifications.
give our viewers a little bit of extra, some places to go on the website, there's the Connecticut Bar Association, which is www.ctbar.org, Connecticut Judicial website, www.jud.ct.gov, Connecticut Secretary of State to search business entities, and that would be your www.concord-sots.ct.gov, and the Connecticut Department of Consumer Protection, which is www.ct.gov/DCP. So I'd like to thank you, gentlemen, both of you. It's been
Thank
a
you.
great,
you. Thank you, Susan.
we kind of superficially covered a lot of things very quickly, but hopefully in the right direction. I certainly appreciate your time for that. I'd like to mention that we are on Facebook, and you can see all of our programs on our website at ctvalleyviews.com. This is Susan Regan thanking you for joining me and bringing proof to the people.